Good evening and welcome to ReachLawyer's Friday Talk Show. Today's episode on Contempt Harlequinade is a part 7 in the series of Desiccating Democracy. But before we begin today's discussion, I'd like to take a moment to introduce ReachLawyer to you. We are a network of lawyers concerned about the rule of law, constitutional morality, and the future of this country. Simply put, ReachLawyer is a legal training and support initiative for civil rights movements, social activists, and individuals to empower them with their legal knowledge. While the core of our activity revolves around our work with legal fraternity, we also undertake various other initiatives to further legal awareness, social legal advocacy, and more significantly, to collaborate with various human rights groups and grassroots organizations. You can look us up at www.reachlawyer.org to know more about us. With that, I'd like to hand over the discussion to our moderator, Ms. Prerna Dadu.
Hello, good evening all. I'm Prerna Dadu. I'm from OB Jindal. And today we have activist and human rights lawyer Mr. Mihir Desai, along with founder of ReachLawyer and former public prosecutor, advocate B.T. Venkatesh, to discuss contempt harlequinade when courts scowl at criticism for the seventh part of the Desiccating Democracy series under Floyding Friday Talk series. Lord Denning, in the matter of Metropolitan Police Commissioner in 1969, observed that we do not fear criticism, nor do we resent it. He contended that the dignity of the court will not be established and respected if free discussion about the court were restricted on the pretext of preserving its duty. Contempt, according to the Indian Contempt of Courts Act 1971, may be civil or criminal. Civil contempt is willfully disobeying an order or an undertaking given to a court. Criminal contempt could flow from an action or publication that scandalizes or lowers the authority of any court, obstructs the administration of justice, or interferes with the course of judicial proceedings. Article 129 of the Constitution of India, it states that Supreme Court to be a court of record, the Supreme Court shall be a court of record and shall have all the powers of such a court, including the power to punish for contempt of itself. There is ample legal jurisprudence that have laid down the criteria that would constitute contempt. Like in the case of P.N. Dua, the Supreme Court held that mere criticism of the court does not amount to contempt. And in case of Badranath Mishra, it held that the vilification of judge in a personal capacity does not render jurisdiction to the court to issue contempt. And only in the case of vilification of a judge in the capacity of a judge could the court proceed with scrupulous care in cases that are clear and beyond a reasonable doubt. However, both of these principles were abandoned when advocate Prashant Bhushan was tried for his tweets in which he posted a picture of a Supreme Court judge on a motorbike and Supreme Court's disappointing performance in upholding democracy. And in latest news, comedian turned activist Mr. Kunal Kamra is also facing criminal contempt proceedings for his latest tweets against the Supreme Court. Not only has Attorney General V.K. Venugopal taken offense to the tweets, but also law students have moved the Supreme Court seeking contempt action against Kamra for scandalizing and lowering the authority of the court. His tweets by themselves are not really offensive. They just try and expose what he sees is the special treatment the Supreme Court gave to Arnab Goswami, which is not available to ordinary citizens and to the number of rights activists who are languishing in jail for years. This point has made repeatedly in the last few months. The cases of Sudha Bhardwaj, Anand Teltumbe, and their two 80-year-olds, Varava Rao and Stan Swami, both ailing in prison, have been compared in contrast to the quick bail to Arnab Goswami. The observations by Supreme Court Judge Chandrachud on personal liberty, while welcome, sound like pieties when just 4 days later, the Supreme Court adjourned a habeas corpus hearing on a jailed Kerala journalist whose crime was going to Hathras in UP to cover the rape and killing of a young girl. He said that we are trying to discourage Article 32 petitions that Chief Justice S.A. Bobde said without noting the irony of his observation. Contempt of court, like many other Indian laws, is a colonial inheritance, and ironically, contempt of court was scrapped as an offence in 2013 on the recommendation of the Law Commission in England. The Law Commission of England and Wales noted that the offence was in principle an infringement of freedom of expression. There were uncertainties about its conditions. Prosecutions were likely to have undesirable effects, including republicizing the allegations, and that it was no longer in keeping with current social attitudes. One does wonder then, what role do contempt laws have to play in a modern liberal democracy? In times when the central pillars of democracy have been reluctant in hearing habeas corpus petitions, the CAA and 370 petitions, its initial observations in the light of millions of poor migrant workers and stay of payment of wages order. In an election year, the court did not consider it urgent enough to examine the validity of controversial electoral bonds, but had the time for an open court hearing in a review in 2019 of Sabrimala. The innovative sealed cover jurisprudence and the court's overindulgence in Assam's National Register of Citizens and then not saying a thing on its completion. And lest we forget the court's constant sexism and heightened sense of false nationalism in rape, marital, beef eating cases, and Babri Masjid case. The old maxim of res ipsa equator, the thing speaks for itself, so clearly applies where people's frustration with the top court is clearly due, if not thoroughly justified. The independence of the judiciary is the right of a people and not judges. The integrity of an institution is determined by the criticism it can withstand. The Supreme Court's contempt verdict in Bhushan's case raises more questions than it answers regarding the bounds between fair criticism and scandalous publication, the chilling effect on freedom of expression, the need to prosecute for an obsolete offense, and about the Supreme Court's own previous conduct. With this, I would like to welcome Advocate Mihir Desai to talk more on this topic.
Am I to start?
Yes, sir, you can begin.
Okay, fine. Thank you. Thanks, ReachLawyer. Thank you, Mr. B.T. Venkatesh, who has been an old friend of mine. Thank you, Prerna. Thank you, Shrikant, for inviting me here. Well, Prerna covered a lot of ground, actually, for me. So, but let me start a little bit with before we go into the present controversies, and the present controversies arise, as Prerna herself mentioned, from two cases. One is, of course, Prashant Bhushan's case, and the second is Kumal Kamra's case. But there are a couple of other cases also recently which have come to light, which have been highlighted in the press, in the media, and various other arenas, which talk about in which the Supreme Court took action in the Contempt of Courts Act, including the famous Justice Kannan's case. There is the case about Mr. Nedumbara, who is a lawyer practicing in the High Court and Supreme Court. There are various other cases. But before I go into the whole question of and the debate over these issues, and the main issue today, I believe, is whether the criminal contempt jurisdiction has at all any place in a civilized world. Should our country continue to have a law such as criminal contempt of court at all or not? Now, please remember, as Prerna herself mentioned, that when we talk about contempt of court, we are talking about two different things. One is we are speaking about civil contempt, which is essentially violation of orders of the court. You go to court, you are being dishoused, you get an injunction against the corporation throwing you out of the house, and the corporation nonetheless comes and throws you out of the house. And you go to court saying that though the court had given an injunction, they've thrown me out, it's contempt, you punish them. That's the civil contempt part. And the debate or dispute is not over whether civil contempt of court powers with the court should remain or not. They should remain, and there is no dispute on that. So when one loosely talks about contempt should be done away with, etc., but when one is talking about contempt being done away with, one is talking about criminal contempt. even within criminal contempt, there are two separate aspects which we must bear in mind. One is contempt in the face of the court, and second is the contempt in terms of scandalizing the court. The contempt in the face of the court, like I'll just give you an example. I was arguing a matter about 20 years back in the Bombay High Court before a judge, and suddenly a kind of a projectile whizzed past my face, whizzed past the judge's face, and hit the wall. It was a shoe thrown by a litigant at the judge, and then that person was arrested, and then that person was tried for contempt, etc., etc. That's contempt in the face of the court. Okay. Uh, in fact, there are cases like in England. There were cases in 1600 in 1623. There was a particular case in England where a litigant shouted and screamed at a judge, and the judge immediately ordered him to be hanged in his presence. So this is criminal. Of course, nobody will order hanging in presence or absence in the present day, but that is what is meant by criminal contempt in the face of the court. What we are talking about today is criminal contempt in the context of scandalizing the court. That is what we are focused on. That is what the debate which is presently going on is about. Remember one thing, that contempt jurisdiction of the court is not a new jurisdiction. It is something which has existed since last 500, 600, 700 years. The original belief was that king dispenses all the justice. King doesn't have the time, so the king appoints people, judges, to dispense justice. And if you insult those judges, you are insulting the king, and therefore you are committing contempt. That was basically the original logic of contempt. That is how the contempt jurisdiction begins. That you are insulting the king, and therefore you are committing a huge, big crime, and therefore you should be punished very severely. That's how it begins. Then, of course, over a period of time, 300, 400 years, it undergoes a lot of change. As far as the law is concerned, there are basically three provisions in the Constitution which provide for contempt. Article 129, what Prerna already mentioned, says that the Supreme Court is a court of record and will have all powers, including power to punish for contempt of itself. It's Article 129. Article 215 gives a similar power to the High Court. And that has been interpreted to mean that when it says that punish for contempt for itself, it has been interpreted by various judgments to mean that even punish for contempt of subordinate judiciary. There are judgments which say that High Court cannot punish for contempt of Supreme Court. You have to go to Supreme Court in case there is a contempt of Supreme Court. These are the two provisions in the Constitution. Apart from the fact that there is Article 19(2), which is a restriction on freedom of speech and expression. And this particular article, which puts restriction on freedom of speech and expression, includes amongst various exemptions the enabling power of the government to make a law concerning contempt. So freedom of speech and expression can be circumscribed by a law being made by the government for punishing somebody for contempt of court. It is under this power that the 1971 Contempt of Court Act has been enacted. So this is broadly speaking the legal part, just to cover the legal ground. The point which is, I think, of great importance and which we need to look at before we even look at any of the cases and go into whether person X committed contempt or Y committed contempt, or whether a particular statement amounts to contempt or doesn't amount to contempt or should amount to contempt or not, is contempt, especially scandalizing the judiciary. Okay, the contempt of and henceforth whatever I say in my talk today will be confined to scandalizing the judiciary, the contempt part which deals with that, not with civil, not with contempt in the face of the court. So I'll be focusing on that, scandalizing the judiciary. That's an exception to freedom of speech and expression. Okay. Now, remember one thing. Theoretically, nobody can be scandalized in the sense that you can't scandalize me, you can't scandalize person X, person Y, you can't scandalize institution X, Y. What happens if you scandalize? You are likely to meet with a defamation case, civil or criminal, okay? And you will be prosecuted and you will be punished for that. Okay? That's what normally happens if you scandalize somebody. Scandalizing in a broader sense, I'm talking about. Okay. Whether it's a parliament, whether it's parliament has its own privilege motions, etc., etc. Now, why does contempt become so important? Okay. Because anyway, you can't. Anyway, if I scandalize somebody, if I scandalize a judge, that judge can always go to the court, sue me for defamation. That has happened in England in a few cases earlier on. You sue me for defamation, saying that he's spreading falsehood about me or he's spreading lies about me, etc., etc. So why is scandalizing judiciary such an important aspect? And why, according to me, I mean, I will be arguing that it should be done away as an offense altogether. Now, remember one thing. Ultimately, what we are talking about is freedom of speech and expression, okay? Freedom to criticize, to condemn, to vilify an institution, namely judiciary. Do I have that freedom, and what is the limitation of that freedom? Okay. Why does judiciary need to be criticized? Why does judiciary need to be at times condemned? Okay. Why do we need to? Why is it such an important right, right for the citizens? I think it's important to understand the crucial part that this right involves in the bundle of rights which the citizen has, in order to understand why we are opposing contempt. Okay. Now, remember one thing. Any institution of the government, be that parliament, be that executive, be that any other institution, whether it's a CAG, whether it's RBI, whether it's CBI, whether it's police, any institution of the government, okay, can be criticized in the most trenchant manner we want. Okay, we can criticize it; it gets criticized. Okay, and of course they have a recourse. They can sue you for defamation, as I mentioned, etc., etc. But if you look at, say, for instance, Parliament, there are accountability mechanisms set up for Parliament. You have a parliamentarian has to get himself elected every 5 years. A parliamentarian is answerable in open parliamentary debates in the parliament, which are open for anybody to witness. There is an election commission, which is an independent constitutional body which oversees the elections. You have a Controller and Auditor General of India, which ensures that the accounts of the executive are properly maintained. You have a right to file FIR in case some offense is committed by a parliamentarian or by somebody from the executive. You have a Lokayukta where you can approach. So the method so there is a control and there is an overseeing of the appointments of these parliamentarians or of the executive. There is a debate, there is a transparency, there is an RTI which is available which one can use. There are independent institutions which we can approach if we have any problems, such as Lokayukta, such as CAG, such as Election Commission, such as CBI, such as police, in case we have any complaints against any of these persons occupying any of these posts. So these institutions, all the institutions of governance, okay, have an accountability and transparency mechanism which is already in place. It's one thing how effective they are, how much they are working, etc., etc. That's a different matter altogether. But they have an accountability and transparency mechanism which is already in place. Okay? I'm not talking about effectiveness of them, but mechanisms being available. Okay? So those who govern the country, those who are our representatives, are answerable to us in various fora, in various manners, in various institutions, okay, for their actions. This is not the case with judiciary. Okay? And that is why criticism, and in fact much more criticism of judiciary, is something which should be invited. Look at the judiciary, for instance. First of all, remember one thing. Everybody likes to say, and possibly rightly, that the Indian Supreme Court is possibly the most powerful Supreme Court in the world. Okay? It's most powerful in various ways. One way is, of course, it can strike down any legislation. It can even strike down a constitutional amendment. It has suo motu powers to take action in respect of any matter. It has developed an entire jurisprudence of PILs. It issues directions to the executive. It issues directions to the to various authorities. It can appoint its own committees. It can set up special investigating teams. It has taken upon itself the power of continuing mandamus, whereby, in fact, a continuing investigation can be monitored by it. It can issue all kinds of directions, and one has examples of it, like in Vishakha guidelines, like in international adoptions, like how a CBI chief will be appointed. So the power of the Supreme Court is immense, is tremendous. And Constitution also recognizes the powers to Article 32, which gives any, of course, irrespective of what Justice Bobde may say or what he may feel, Constitution doesn't get changed by what he feels. The Constitution says that Article 32, fundamental right, we can approach the Supreme Court whenever we want to. So one thing which we have to bear in mind is the Supreme Court of India is an extremely powerful body. Second thing is, it's an unelected body, okay, which is okay. I mean, in many places it is unelected, not everywhere, but in many places, which is fine. But at the same time, you have the appointments in the Supreme Court being made through a collegium system, which is completely non-transparent. We do not know why somebody is rejected. We do not know why somebody is appointed. Similarly, the case of transfers, we do not know why a Justice Qureshi gets transferred. We do not know why a Justice Oak doesn't get promoted to the Supreme Court. We do not know why a Justice Muralidhar is transferred overnight. Okay, so there is no transparency at all. The tenure of the Supreme Court judges, unlike the parliamentarians who are there for 5 years, okay, is till they retire, till they are, or High Court judges till they retire, 65 or 62. Okay, they can't be touched before that. Of course, impeachment is there, but it's never been used. Okay. The Right to Information Act is very, very truncatedly available to them. They say that it doesn't apply to us on various aspects. Sexual harassment committees are not applicable to them. We saw it in Justice Gogoi's case, what happened. Supreme Court itself has laid down in a judgment that if any judge of the High Court or Supreme Court against any judge of the High Court or Supreme Court, an FIR has to be lodged, the Chief Justice of Supreme Court's permission has to be taken before you can even lodge an FIR. You can't go on, making you can't investigate seriously allegations of corruption against a judge. So you have a situation of this. So you have at one level a very powerful judiciary, on the other level a completely unaccountable and non-transparent judiciary, and thirdly, you have tremendous amount of backlog. People are frustrated. You have crores of cases which are lying. You do not know why an Arnab Goswami's case gets taken up first and not Varavara Rao or Stan Swami's case, or for that matter, any of the 3.5 lakh under trials who are presently languishing in prison. It is extremely an expensive place to approach the Supreme Court. The judgments are varying. You don't have consistency within the Supreme Court. Supreme Court doesn't speak with one voice. The power of assignment, and this is not just what I say. Okay, you had the experience of 4 judges of the Supreme Court coming and taking a press conference. You have had a case of Justice Chandrachud writing a letter about the manner in which the sexual harassment case was handled by the Supreme Court. So you have a situation whereby you have a very powerful Supreme Court, a completely non-accountable and non-transparent Supreme Court, and a Supreme Court in whom people have been losing faith, a lot of arrears, very expensive, varying judgments, complete arbitrariness. In that kind of a context, okay, it becomes absolutely essential that people are allowed to criticize the Supreme Court. It becomes absolutely essential that people are allowed to demand from the Supreme Court that, look, what is happening is completely wrong, completely arbitrary, completely unjust. And we are not only talking about judgment X and judgment Y, because the Supreme Court has, of course, said that criticizing in a temperate way a judgment of the Supreme Court does not amount to contempt. But that's not what I'm talking about. I'm talking about the system as a whole. I'm talking about the judicial system which has failed to deliver. Okay? It is in that context, okay, that we have to see the contempt law. Okay? Because it is in that context, in this larger context, which I'm trying to advance, where we have seen a complete failure of the Supreme Court to respond to situations, whether it's of migrant laborers, whether you see a situation whereby very, very important cases like the case of capital bonds, like the case of Article 370, whether the case of CA-NRC, whether the case of Delhi riots, whether the case of Bhima Koregaon, when these cases, okay, are not given priority, and the priority is given to whether Mr. Goswami should be day after tomorrow released, today itself released on bail instead of allowing his bail application to be argued tomorrow or not, then obviously people are going to raise questions. And I personally don't feel, okay, that anything which, for instance, Mr. Prashant Bhushan said in his talk, or anything which, for instance, what Mr. Kamara is alleged to be guilty, alleged to have committed contempt of. I saw his tweets, the initial tweets, I've seen those. People are criticizing, and you are living in an age of social media. Please understand that respect is not something you can coerce out of people. Respect is to be earned. You do good job, people will respect you. You do bad job, people are going to criticize you. Okay? And instead of charging people with contempt, instead of punishing people with contempt and spending time with it, I feel it is high time for the Supreme Court to reflect on its own. Where has the judicial system failed, and why is it failed? Okay, what is the Supreme Court doing about it? We don't know, because it's a non-transparent system. Okay? Any action taken again? I mean, I could have very well understood. I mean, just to give one example. Okay? Today the judgment came in of Justice Chandrachud in Arnab Goswami's case. Okay? And he goes at length and criticizing the High Court for not having done this, not having done that. Fair enough, okay. But one of the important things in Arnab Goswami's case was that 2 years back, an FIR lodged against him by the police was closed through a closure report. Now, the law of the Supreme Court is, and this is not law laid down yesterday or day before, it is a consistent law since last 20 years, that if the police is filing a closure report, okay, then the victim or the complainant has to be given advance notice, has to be given an option of applying through a protest petition to oppose that closure. I would have been very happy if Justice Chandra, and this was not done when the FIR was closed 2 years back. Admittedly, no notice was given to the victim or to the complainant as to the fact that we are closing the case. Okay, so this was a misconduct by the magistrate. Okay, this was a misconduct. I was looking forward to Justice Chandrachud's judgment saying that this magistrate has conducted misconduct and so he should be punished. That's looking inward into yourself, into the judiciary. That, look, we have committed a mistake, let's look at it. But that I do not find. Okay? So what we do find instead, okay, is that a Supreme Court which has been losing its credibility, and I would love a strong Supreme Court. I would love a Supreme Court in which every citizen has complete and unimpeachable faith. I appear in high courts and Supreme Courts, and I would love to see an institution like that, and I would fight for an institution like that. Okay? But what we have today, okay, look at what happened in migrant labor's case. Same kind of situation. I mean, I need not explain what has been happening. So broadly, what I'm trying to say is this, that Supreme Court should open itself. I mean, in England, the law has been, as Prerna herself mentioned, in England, the law has been done away with in 2013, this scandalizing the court. In USA, where the law on paper does exist, where a criminal contempt can be lodged, it can be lodged only if there is a clear and present danger, an imminent danger to the justice delivery system. Only then can you try somebody for criminal contempt. Same is the situation in Australia, same is the situation in Canada. Okay? All these countries have realized over a period of time that shutting people's mouths is not the way to make the judiciary answerable. That's a way of making judiciary autocratic. That's a way of making judiciary completely unanswerable to anybody. And that's not how we want to go forward. We are living in a democracy. We want a judiciary which is accountable. We want a judiciary which is transparent. We want to move towards that kind of a judiciary. Unfortunately, presently, that trend is not. We are not going towards that. Okay. The courts yesterday, Justice Ramanna, in one of the Constitutional Day lectures, said that we are unnecessarily being criticized. Well, the point is, I wish they examine a little more carefully as to why they are being criticized. Okay. I would want to know why, for instance, Justice Qureshi was transferred to the Northeast rather than to Madhya Pradesh. I would like to know, for instance, why Justice Muralidhar is transferred overnight when he's about to give a decision in a case concerning Delhi riots. I would like to know why certain judges who are very, very senior are being bypassed in being appointed to the Supreme Court. I would like to know why the brother of a judge who was still till now sitting in the Supreme Court, okay, has recently been appointed as a judge of the Madhya Pradesh High Court at the age of 44. I would like to know that maybe he's an excellent judge, but then I would like to know why he is being appointed. I would like to know, for instance, okay, I would like to know that why a woman who made allegations of sexual harassment against a chief justice, okay, and which allegations, according to the Supreme Court, were false, was reinstated. Why was she reinstated if the allegations were false? And if the allegations were not false, why is the committee report not being made public? Why is the public not entitled to know what the Chief Justice did to that woman? Okay. Article 14 applies equally. Article 21 applies equally to Supreme Court, okay, and to the high courts. And therefore, I think it is important for all of us, okay, to say that this antediluvian law of contempt, of scandalizing the court, okay, should be done away with. If a judge, of course, does it mean that judges will not be wrongly criticized? Yes, of course, they will be wrongly criticized at times. Okay. Just as parliamentarians are wrongly criticized, just as police commissioners may be wrongly criticized, just as anybody else may be wrongly criticized, they will be wrongly criticized. The answer which they said, look, we can't talk to the press. Well, in the last 3 years, that has also been proved wrong. 4 judges of the Supreme Court did go and talk to the press. One judge of the Bombay High Court did talk to the press when the Justice Loya episode happened. Okay, so it is no more the case that judges don't talk to the press. They do go and give lectures in various functions and various programs. They can definitely defend themselves in those programs and their functions. Okay, so just second thing is that they can always file a case for defamation or libel if they want to. And the most important thing is if really, I mean, as Justice Bharucha said in Arundhati Roy's case, that our shoulders are too broad to be bothered about these kind of criticisms. We will do justice according to what we think is right. And just because somebody criticizes us, just because somebody abuses us, it's not going to affect us in our cause, because we are independent judges sworn to the Constitution of India. And I think that should be the approach of the court. And if you look at Prashant Bhushan's judgment, lastly, I just wanted to put that if you look at the judgment in Prashant Bhushan's case, uh, it's it's about 135, 140 page judgment where they find him guilty of contempt. Okay? But that judgment doesn't discuss the substance of what his allegations were. The substance of his allegations were, in the last 6 years, the democracy has been eroded, which fine, the court feels it's a matter of opinion, that doesn't amount to contempt, that the Supreme Court played a role in eroding this democracy, and that the last 4 chief justices have played a role in eroding this democracy. And there is no discussion. Let me put it very frankly and bluntly that I agree with what Prashant Bhushan says. I have no qualm in saying that. But I feel that the Supreme Court ought to have, okay, at least dealt with the allegations which he raised, okay, which have not been really raised with. And there is an attempt made to deal with those allegations in the punishment judgment, which came later on, but which is hardly an attempt if you look at the judgment. So let me end by saying that according to me, this looking at the power of the judiciary, looking at the complete non-transparency and non-accountability of the judiciary, it is absolutely essential that the power to put people behind bars, to punish people for so-called scandalizing the judiciary, has no place in a democracy like ours, and it should be done away with. Thank you very much.
Thank you so much, sir. That was a very interesting talk. Before we get to asking questions, I would like to invite Advocate B.T. Venkatesh, sir, to talk a little bit more on the topic.
Thanks, Meher. It has been a joy listening to you. We've opened up a large body of subjects to discuss. In fact, many people in this country are asking this question: why we have these different standards? One of the major questions people are asking is that we come across the indiscretion of the judges, which is on record. We come across statements, very scandalous statements made by the judges in the course of their judgments, in the course of their intercourse in the court, the kind of communications that they make, the kind of observations that they make. It's a shock, in fact, very misogynistic, patriarchal. It may sound very simple, but the thing is that the language, the terms that are employed, which go to show that that would scandalize the very institution which they function. That's something which shocks everybody. In fact, we come across a judge of Meghalaya High Court who said that India should have declared itself as a Hindu Rashtra at that point of time. Is it not something which a judge knows so well, that what exactly he has sworn to, the kind of office he holds, the kind of responsibility that he holds, the nature of his appointment? Is he not aware of the same? In fact, this is something which people are asking questions. So is this case of a Supreme Court judge who said that violence on the daughter-in-law by the mother-in-law is okay. It does not amount to cruelty. Can we look at that? Is not scandalizing the law, scandalizing the institution? So is the case where there are umpteen number of instances where we have seen judiciary found wanting in its observation, in its behavior. In fact, what you have mentioned regarding transparency is one part. There is also a large part. In fact, people are asking questions, how could someone so bad could be elevated as a judge? And how could someone so bad continue to be holding that kind of a position? Now, when the way this functioning happening, the kind of instances that we see here, one thing which comes to the mind of a common person is that whether the judiciary, by through such judges, not scandalizing itself of the institution's values which it speaks in terms of the kind of powers that are vested with it. This is something which is a question which is lingering in the minds of many citizens of this country. This is something which all of us ask questions. Why? There are varying degrees of understanding regarding contempt is concerned. So, for example, we had the case of Shiv Shankar, the way the case was conducted. So we saw the case of Arundhati Roy. So we saw the case of Prashant Bhushan. So we are seeing the case of Kunal Kamra. And there are a number of other cases in between. Not only this. In fact, I come across a case in Jharkhand where a person who questioned the land acquisition of the High Court for a national law school in Jharkhand was taken into consideration that she was prosecuted for contempt. What makes it so, when she made a question regarding the same, there was a report in a magazine in a newspaper in Karnataka regarding corruption in judiciary, maybe a possibility in respect of one particular incident which was factually incorrect. The media house was hauled over and there had to be a huge amount of penalty for it. The question here is that ensuring that kind of respect for the institution of judiciary, it is not through such kind of action, rather by demonstrating exemplary standards. In fact, just a couple of days ago, we heard the report that the Supreme Court of India, whose judgments are welcomed across the globe, the report and cited as law in many countries, now it has come down that you don't have many in the last 6 years to 7 years which are being reported as well. What exactly is happening? And also happening regarding the ability of these judges, the kind of quality of the judges that who are being recruited, because today there are nearly hundreds of judges are being recruited to the various high courts in the country. What exactly are the yardsticks? In fact, Meher inquired regarding the absence of total transparency in recruitment is concerned, absence of transparency in transfer is concerned, absence of transparency in elevation is concerned. So when you look at such amount of opaque structures that we are keeping, and we refuse to accept that the institution refuses to accept that, yes, it's open for a kind of a discussion, demonstrates that whether such law of contempt, of scandalizing the court. So when we talk in terms of contempt of court, for most of the people, it's this part of the contempt that's being discussed. And even for our discussion today, the subject that we are talking in respect of that particular part of the law of the Contempt of Courts Act related to scandalizing the court, which the court has powers of punishment. Is it not arbitrary in its nature? It's something which is of question. In fact, we had this great case of Daily Mirror's case in London, the law lords and spy catchers case, the decision spy catchers case. The specific names for photographs were placed of 3 law lords inverted and said that old fools. And Dr. Lord Templeman made a statement, Lord Templeman made a statement that I'm old is a fact and that I'm a fool is a matter of a perception of others, not me. So kind of that kind of understanding, that kind of degree of sanity is something that is needed. In fact, it went to the extent of Daily Mirror accusing the judges as enemies of the people. In fact, recently we had the case in United States where the President of America Donald Trump, accused the judge of the Supreme Court, saying that he was a disaster to judiciary. So when we have kind of statements that are being made as against judiciary, is it when we do we say that is it not scandalizing the court? Why those places we have the people right to speak? Today, when we talk in terms of the judgments passed by the Supreme Court, as we are entitled to have an opinion, we feel that a particular judgment is wrong. On certain facts, if I have my opinion on my basis of my understanding, you see that there is a findings on this particular aspect is incorrect. Yes, certainly, I would say that the judges were not correct in that particular aspect. I'm entitled to criticize the judgment. I'm entitled to criticize the judges and their opinion. That's the freedom that we have. That's what that comes within the ambit of freedom of expression. I think given that kind of a situation, there is a need that this law need to be discussed at length. In fact, today, I would like to request Meher to delve upon this particular aspect, the judges scandalizing the court itself, and the kind of statements that we have, the kind of absolutely the observations which are made, it shocks everybody. In fact, we had a case some time ago, a judge asking us in the court hall that go and get me Civil Evidence Act when someone was trying to asking in the civil appeal matter, when the evidence was being discussed in the trial court in the second appeal, when the lawyer took the Evidence Act from a criminal manual, the judge informed him, don't use that particular book, take the Civil Evidence Act. It does not exist in this country. There's only one Evidence Act. A judge of the High Court does not know this fact. It is shocking. But it goes into a particular. We have a number of instances of this nature where the judiciary is found wanting of its quality, caliber. It is found wanting in its observations. It's found wanting in understanding the constitutional values which are the basis of their interjudicial process that need to go into this particular, in this country. I think somewhere when you look at it, there is element of scandalizing. Today we have Meher Desai. Meher Desai is a senior advocate of Bombay High Court, one of the most reputed advocates of the Bombay High Court. A person who needs no introduction, a person who has been working for the human rights. His other name for fighting for human rights is concerned, whether in Bombay High Court or in Supreme Court, any way you want, he is going to be there fighting for the causes of human rights and civil liberties for decades now. He's also the founder of Human Rights Law Network and India Center for Democratic Rights. The amount of work that has done over periods of decades demonstrates his commitment to the process. And in fact, today when he talks in terms of it, he talks in terms of that kind of concern that all of us have in protecting the kind of institution that we are working with. That's a necessity of protecting an institution of judiciary, which is essential for a nation like India, because this is one of the most important institutions which makes democracy possible. And unfortunately, today, the kind of acts of the judgment, the kind of procedure that are being employed, the kind of the delay that's happening in certain cases, the kind of absolute driving certain cases to insignificance, despite the fact that they cry attention, demonstrates that all is not well in the judiciary. It also demonstrates that taking cases of this nature, the courts are opening themselves to much larger criticism. That's something which is happening. I request Meher to delve upon the court scandalizing itself, the kind of misogynistic statements that the judges make, the kind of judgments which were per se patriarchal and against the very construct of the rule of law in this country is concerned, the kind of statements and observations made by judges which shocks everyone. We come across these kind of statements and the observations by the judges reported widely in the press. And such is the case, whether it does not amount to scandalizing the court, whether it does not amount to scandalizing the court such degrees. Many a time we come across. We had this case of slapping contempt. In fact, we also discuss regarding Patricia Mukhim's case. Patricia Mukhim is a very senior media person from Meghalaya, long times. She had been prosecuted for contempt of court. The matter is pending in the Supreme Court at this point of time. But anyone who talks against the institution, why this institution gets into a hurdle immediately and try to say that no, we will not accept any kind of criticism. Is it above criticism? Is it not part of the institutions that we are working with? In fact, when we were discussing regarding the accountability, which is there in all the other aspects, the absence of the same in the judicial process, judicial institution, questions of this nature are really being asked. I think I request Meher to explain on the judiciary scandalizing itself in these kind of situations. Why it does not, how it becomes that such observations are they're struck off from the record and it's done with. It's such easy an option. But whereas when it comes to someone else making any criticism, even a very valid criticism, the one which Prashant or anyone has made, it's taken with such degree of offense. And why it happens? I think I request him to delve upon this aspect. It will be very essential for today's discussion. Thank you.
Thanks, Venkat. Let me just start by saying something which happened yesterday in the court. This didn't happen in either the High Court or the Supreme Court. It happened in the Sessions Court. I am representing some of the Bhima Koregaon accused in the cases which are going on against them, including Father Stan Swami, who is the 83-year-old Parkinson's disease suffering priest who was arrested for no rhyme and reason, and he's in jail. And a couple of weeks back, we had asked that he should be provided. Because of Parkinson's, he can't hold on to a glass, can't hold on to a cup. And so it falls. So he needs a sipper in order to drink any liquid. He said that please provide. 3 weeks time was given for the NIA to respond. NIA responds yesterday saying that, well, we don't have the sipper. So now the court has given 4 more days time to the jail authorities to respond, etc. In the meanwhile, the guy goes without any sipper or any without drinking any liquids. The point which I'm trying to make is that this had become a very big issue in the media. Namely, that an 83-year-old man, possibly even in other parts of the country, it might have been reported that this man has not been allowed to, be given sipper. On the other hand, you are talking about personal liberty, etc., etc. And what the judge was very wild about yesterday when the case came up was that how the media is reporting so much. He was not bothered about what he had done, what the police authorities had done, what the jail authorities had done or not done. He was most concerned about why the media was reporting this. Why was he being criticized so much in the media? This is the oversensitivity of the judges, okay, which you find in in various matters. Okay, because whether we like it or not, the trials in the country are open trials. Unless they are ordered to be in camera, they are open trials. Media has access to it. Media can write. And many times what happens is judges do make a lot of, there are certain remarks which are made while interacting, which are not necessarily reflecting the conclusion of the judge. And at that times they get upset, maybe rightly so, that look, we made that an off-the-cuff remark. Why is the media playing it up? But there are certain remarks which are made by the courts, by the judges in court, which media reports, or which even if they don't report, these are so scandalous. I don't know whether you read about. Many of you must have read about this High Court judge from the Rajasthan High Court talking about how the what are they called, the he pens, or they actually procreate through tears and not through actual sexual activity. This is the kind of knowledge they have when they become judges. In fact, there is one more area of contempt which was developed in England, which has really not developed in India so much, which had developed in England earlier, which is contempt of their own court. Okay, that is judges being guilty of contempt of their own court. Okay, making statements or passing judgments which may be, if it's a corrupt judgment, then they are found to be, then they are held to be guilty of contempt of their own court. Or if they are very abusive, they are held to be found to be guilty of contempt of their own court. Now, this issue actually, what has been happening is that there are 3 or 4 actually layers to these issues. One is not necessarily you have the level of competence amongst the judges which you need uh, at all levels. Okay? The level of, I mean, there are some excellent judges, but there are also some mediocre judges. I mean, that's a reality of life. Uh, there are many judges who don't have a clue about the law. There are many judges who want to keep on giving lectures about morality in a very misogynistic manner, who in a Victorian morality kind of sense, from which they have never grown up, that kind of thing. This keeps on happening in court, and many times the judges, many times the lawyers, because as lawyers, you are not only thinking about the case which you are arguing, you are also thinking about the fact that you are going to appear before this judge tomorrow, day after, the day after. So many times the judges don't confront the judges, even if they know that they are wrong. Okay, this happens. This happens a lot of time. So what happens is judges give lectures, they pontificate, and I call some of the recent jurisprudence of the Supreme Court as pontificatory jurisprudence. Pontificatory in the sense that it talks about grandiose things, okay, but concretely it doesn't help a single person in life. Okay, that is what has been happening. It talks about grandiose things, but concretely it doesn't really help a single person in concretely in their lives. And judges, many judges, not obviously not all, there are serious and very grand exceptions to this. Many judges like to pontificate sitting on the bench. The bar many times has no option but to listen to it, because they fear that if you stop him, or if you digress his attention from one to the other, there'll be a problem. There are of course very famous famous anecdotes, okay, in the past. Okay, I just like to say one or two to bring a lighter vein to it. That once there was a judge before whom Mr. Bhulabhai Desai, was a very reputed lawyer pre-independence, was arguing, and the judge told Mr. Bhulabhai Desai that look, you can keep on arguing what you want, but what you are arguing is going in from one ear of mine and coming out of the other. Basically, he told him that, I mean, you want to argue, you argue. I've lost interest. So whatever you are arguing is going in from one ear of mine and going out of the other. So Bhulabhai Desai immediately retorted, yes, I know there is nothing in between to retain it. Okay. So now this is a kind of boldness. Okay. Which you could see at one time when lawyers were bold enough to tell the court that what you are doing is wrong, what you are saying is completely wrong. Okay? You have, I recently heard Mr. Kapil Sibal, arguing the matter of Arnab Goswami on behalf of the state of Maharashtra in the Supreme Court. When he pointed out to Justice Chandrachud, of course in his own polite way, Mr. Sibal, he pointed out to Justice Chandrachud that look, here is on the one hand you are talking about that even one day Arnab Goswami should not be in jail. On the other hand, you have a person who goes to report Hathras, okay, in UP, and he has been in jail since last so many days. When I approach the Supreme Court says it might be better for you to go to High Court. So what is happening? So I think it becomes important. While on the one hand, you have a situation whereby a lot of news statements, which are based on some antediluvian morality which are being made out. I think it's important that the lawyers also stand up to them, and lawyers also, the bars have to play an important role. Unfortunately, the bar associations across the country, barring a few exceptions, have succumbed. And what we are seeing as far as the Supreme Court is concerned, okay, namely resistance to any dissent, is not is only a wider reflection of what is happening in the society as a whole. you have an establishment, a political establishment, which is also resisting to anything, to any dissent of any kind which it meets. So you have a situation like you have today, farmers being water cannoned and being jailed and being thrashed. You have workers suffering from the same thing. So what is happening in the judiciary is but an indicator of what is happening in the wider society. And our fight within the judiciary will not end till our fight in the wider society also leads to a better situation. That's all I wanted to say. Thank you, Venki.
Thank you so much, sir. We'll now be asking some more questions. So I'll start. Sir, do you think that India is lacking in properly enunciating its freedom of expression itself, where the right to criticism is not fully being understood as part of it? Like, for example, America has its First Amendment, right? So when there is, even within the civil political discourse in India, the language of being labeled anti-national for every single criticism, that's not only within the top tier courts, but also in how Twitterati is sort of interacting with itself. So where do you think the freedom of speech itself has is sort of coming short in identifying freedom to criticize within itself?
Sorry, you want me to answer this one question, or you want to take one or two questions and then answer? As you wish. I mean, I leave it to you.
So you can answer this. Until then, I'll also collect questions from everybody else.
See, let me put it this way, that I have a lot of respect for Mr. Jawaharlal Nehru, okay? But I think he was a person who brought in these restrictions on freedom of speech through the First Amendment, okay? And he is to be squarely blamed for that. Before the First Amendment of the Constitution, okay, if you look at the freedom of speech and expression, Article 19(1)(a), okay, you had exceptions, of course, but exceptions pertaining to contempt of court was there, defamation, slander, etc. But as far as security of state was concerned, it was the exception was that you can make a law to restrict freedom of speech and expression, okay, in order to if that speech undermines the security of state. That was the exception. Amendment 1, First Amendment, which was brought in 1951, okay, that amendment for the first time brings in the exception that changes the language from undermining the security of state to in the interest of security of state, and also brings in the additional ground of exception of public order, which did not exist. So your sedition, okay, which today is being misused, the law of sedition is being misused today to charge anybody. The way the UAPA has been structured, the way TADA was structured, the way POTA was structured, it could not have been possible but for the fact that the First Amendment changed the Constitution as it originally stood. Okay, so in one sense, I feel the Constitution as it originally stood on 26 January 1950 was much broader, okay, and gave us much more rights in terms of freedom of speech and expression than the subsequent amendment, which took away some of those rights. So that's one thing. Okay. Second thing is, of course, over a period of time, you see, unlike even in USA, it's not an absolute freedom of speech and expression. There is the test of clear and present danger of violence, etc., which exists in USA. In India, there are judgments and judgments. You see, unfortunately, in India, the Supreme Court doesn't speak in one voice, unlike in USA, because they sit in block. So you have judgments and judgments. There are some judgments which say clear and present danger test is a valid test to decide whether a speech should be restrained or not. Okay. On the other hand, you have some good judgments like 66A, which was set aside by Justice Nariman in his Shreya Singhal judgment, where he said that this is overbroad, And he makes the clear distinction at through three levels: discussion, advocacy, and incitement. So he says very clearly that even a speech which is at the level of discussion, even if it's unpalatable, is fine. Even if it is a level of advocacy, say a violence at the level of advocacy, is still fine. But if it reaches the level of incitement, only then you can stop it. But as I said, the problem is that who is going to explain this to the police, and who is going to explain this to the authorities, to the CBI, to the NIA, who actually go around implementing this? So you have a large number of cases. Supreme Court in 1962, okay, said, whittled down the sedition law to say that unless violence is a result, okay, you can't apply sedition. Even then, routinely, even against cartoonists, even against artists, sedition is applied. Even against journalists, sedition is applied. And while it may be after some time be struck down, those people are in jail. It has a chilling effect on people. Okay, so what is happening, and no action is taken against the police. I mean, ultimately, if you are wrongly applying a law and the court comes, that's precisely why I was giving the example of Justice Chandrachud's Arnab Goswami's judgment, that if you are wrongly applying a law and putting people behind bar, and you are giving so much importance to public liberty, okay, why are you not directing action be taken against those police officers who put you behind bars in the first place? Okay. So I personally feel that freedom of speech and expression, uh, in terms of its width and breadth, is not as broad as it should be. Its breadth has been reduced by the First Amendment of the Constitution, coupled with various laws which have been passed, whether UAPA, whether the press control laws, etc., which were passed in 1951. Okay. But even then, okay, whatever the freedom of speech of expression exists, it is being today stifled. Okay, even the limited freedom of speech and expression is being stifled in various ways, and that is leading to a chilling effect on people. And that is something, and that obviously affects dissent, that affects difference of opinion, and that ultimately affects democracy. And so what is happening today is, by imposing this very restrictive standard of freedom of speech and expression, we are eroding, and if not, we have already eroded our democratic institutions and our democracy as a whole. Thanks.
Thank you so much, sir. That was a very interesting answer. Another question is, there seems to be only very few people that are even from like the top elite classes that are attacking the court on their double standards and calling them out. So firstly, do you think the chilling effect is working, that because there are only very few people that are being called into contempt because of this? And secondly, when people are questioning the Supreme Court on its transparency, how is the sort of response that, how is the Supreme Court responding to allegations of it not being transparent anymore, especially when the judges that did that came out and did a public hearing to warn people about democracy being at stake. Even then, nothing really happened. There was no action. So is the Supreme Court just being quiet when it's being alleged that it's not being transparent anymore? Or is there a particular answer that it's giving and also evading it at the same time?
See, even the Supreme Court has some very good judges, and I'm sure there are murmurs within the judiciary, both at the High Court level and Supreme Court level, about the way things are going on. We don't know because we are outside that structure. Now, look at the response of the Supreme Court when the question came about RTI, right to information. Okay? The question was that should you declare your assets to the public? Okay, what are the assets you hold? Okay, should you declare it to the public? Earlier, no assets were being declared. Now, the response of the Supreme Court is that voluntarily those who want to declare their assets, those judges, should declare it on the website. So if you go to the website today, okay, of the Supreme Court, of various high courts, you will see some judges' assets being there, others' assets not being declared. We don't know what the assets are. That doesn't necessarily mean a person X is corrupt or person Y is not corrupt, but at least this minimum that you declare your assets, even there is a major resistance of the Supreme Court. Okay? That we don't want to. The other thing, the collegium decisions, for instance. One of the issues which was raised by a lot of people was that you, in collegium, you take major decisions. Okay. Earlier, the decisions of the collegium were not being made published. There were there were two questions raised, that you are not telling us what the decisions of the collegium are, and second thing is, you are not telling us why decisions are taken by the collegium in a particular way. Okay? So they found a way out. So the decisions of the collegium started being put on the website. Okay? But why those decisions were taken, what caused those decisions for being taken, has not been put on the website. So there is a pressure. There is a pressure to which it reacts a little bit. It knows it has to be to show some amount of transparency. It shows some amount of transparency, but beyond that, it has not been forthcoming in doing that. As far as people writing about the Supreme Court, the elite or others, remember the Supreme Court initially in migrant workers cases during the lockdown, okay, was acted in an extremely unconstitutional way, in just throwing out those petitions, merely relying on Mr. Tushar Mehta's words that not a single migrant is walking on the street today, when anybody who peeped out of his window even during the lockdown could see thousands of people walking on the street. Okay. Supreme Court, unfortunately, possibly the judges live in houses which don't have windows, I don't know. Okay. So they didn't realize it. Then a number of people, including retired judges of the Supreme Court, including very reputed jurists like Mr. Fali Nariman, various other people, started writing saying that what is happening to the Supreme Court? How are you not acting? And then Supreme Court suddenly realized that the criticism was becoming too heavy and took suo motu action and started started acting on the issues of migrant labor. So two things this shows you, that there are people, even amongst the elite, even amongst very prominent jurists, retired judges, who have now begun to speak out. And second thing is, when they actually speak out, the Supreme Court does listen. Okay. To what extent Supreme Court does hear, to what extent it listens is a different matter. Okay. So that is slowly growing. Okay. You might have recently seen articles by Pratap Bhanu Mehta about judicial barbarism and another article by Navroz Sirvai in Indian Express supporting that view. Okay. So if you see 10 years back, you did not have lawyers coming out and openly speaking like this. But now you have practicing lawyers, you have academicians coming and speaking out like this. So while there is a chilling effect, there is also a resistance from the civil society, which is happening. So one has to look at it from both angles. Thanks.
Thank you so much, sir. I have one last question. One of the main reasons contempt is also applied is to sort of maintain the trust and faith that people have in the institution. So now, when the Supreme Court is also showing its partiality and bias in the way it's giving out judgments, and also on the other hand issuing contempt, do you think we're headed towards a situation where there is already quite a bit of loss in faith in terms with the executive? Now there's going to be loss of faith even within the judiciary. So what do you think is the way forward, especially with now the farmer protests and everything going on? Your only challenge, apart from resisting on the streets, is also filing petitions in the judiciary to fight these at a legal level to bring about any sort of change. So now, when both of these avenues are shut, and then there are not much recourse left to do, and even when people, if are going on streets, are being met with heavy violence from the state, so where do you think, what road do you think we're headed towards?
Let me put it this way, that I always believe that while people may have lost faith in the executive, and are losing faith in the judiciary, because a judiciary which doesn't cater to 80% of the population would obviously not have faith of those 80% people. At the same time, still people do have respect for the judiciary. People still feel that possibly in the court something will happen, and therefore they keep on. But I always feel that judiciary likes to believe that people come to the courts because they have faith in it. I always believe that people go to court not because they necessarily have faith in the judiciary, but because they have no other option. Okay, so that's one way of looking at it. But I also feel that as citizens of this country, our constitution grants us certain rights, and one of the most important rights is that of judicial review, okay, of approaching the court, of using the spaces, the democratic spaces in the court in order to agitate for our rights, okay. And no matter how eroded those rights may be, no matter how eroded the that institution may be, we have to reclaim that institution. We can't abandon the judiciary and say that now we'll stay out of the judiciary and we will not go to the court, etc., etc. I think we have to have a redoubled fight to reclaim the institution of judiciary for the purpose for which it was originally meant, and under the constitution, that is for serving the 80% population of this country. Okay, so we can't give up that fight. We have to push on. Yes, you will have. I am an eternal optimist. I always believe that this fight can be won. Okay, within the judiciary, and therefore I always feel that of course one has to go selectively. One can't just blindly rush to the court, etc., etc. That's one thing. But I am also a believer that social change, for bringing about social change and economic change, judiciary is only a small part, has a small part to play. The real change is brought about on the streets. Okay, it's the peaceful protests, it's the agitation, it's the civil society's mobilization, which really ultimately brings about changes in the way democracies function. Whether you see what is happening in Ecuador today, what happened in Venezuela, what is happening in various parts of the world, even today, especially in Latin America, in some parts of Africa, it's the people coming to the street, reclaiming the constitution. And I think that is ultimately yes, there will be resistance. Yes, you will be met by police power, and that has always happened. All authoritarian governments meet power with power, meet all kinds of resistance with power. But that has to needs to be tackled. That needs to be fought in a constitutional way. And I think it's very important. And I completely go by Dr. Ambedkar in all respects except one. Okay, I completely agree with his various writings on majority of the issues, but on one aspect I have a difference. On the Constitution Day speech which he gave when the Constitution was presented, he said one thing, that now that we have a Constitution, okay, we have to now give up this idea of protests and satyagrahas and all that. Okay? Because now we have got this Constitution for us. And I think there he was wrong. Okay, I think we need to continue with those methods of mobilization in order to reclaim the Constitution which Dr. Ambedkar gave us. Thank you very much.
Thank you so much, sir. I'm out of questions. I think Shrikant has one last question to ask you.
Yeah.
So looking at whether courts are, the state of courts right now, and the fact that the Supreme Court is resisting Article 32 cases, how far away is this from democracy?
Yes, I mean if you look at the way the Supreme Court has functioned in the last 4 or 5 years, I personally am very disappointed with the way the Supreme Court has been functioning in various aspects. It's not just a question of Article 32. Article 32 is, of course, as it was said, it's the most important of the fundamental rights. But even apart from that, okay, if you see on a series of issues, there has been the more important problem, I think the crucial problem right now is that Supreme Court, instead of being somebody who scrutinizes executive action, okay, has become somebody who enforces executive actions, who has become a body which justifies, who is a justificatory body of executive actions. It is slowly becoming that. And that's the danger. That the whole purpose of the Supreme Court is to make the state answerable, okay, to the people. But if, on the other hand, the Supreme Court, instead of making the state answerable to the people, keeps on justifying every action of the state in various ways, okay, keeps on deferring to the state, keep on over-respecting towards the state, and rather than scrutinizing their actions in a legal and constitutional way, that's the danger. And what you are saying is right, that these are dangerous times, but there have been dangerous times in earlier times, and people have fought those dangerous times. And I think we should never lose hope. And I never lose hope. I feel that we need to continue with this battle, continue with this fight, and victory will be ours, because the truth is on our side. That's how I would like to believe. Thanks.
Okay, thank you so much, sir. With this, I'd call this session to end. Thank you, everyone, for being with us today. I hope everyone's learned a bit of something and will continue reading, writing, and speaking out against what is wrong and what is unjust. Until next time, thank you so much for being here today. Thank you so much, Mihir sir, for taking our time and sharing some valuable insights. Thank you. I'd just like BT Venkatesh sir to just come and give ending conclusion to the show. Thank you.
Thanks, Mihir, for coming to us today and having discussion with ReachLawyer. It's a subject which is very relevant at the times that we are living in. When we see the kind of abuse that happens, the right of association is being denied to people, right of expression is being denied to people, people are being arrested, stopped, beaten, tear gassed for protesting. The kind of laws that were being made, which they are very clearly saying are against the interests of the farmers in this country, a country 70% of which depends upon agriculture as its activity, main form of employment and activity. I think such is the kind of situation that we are in. I think the subject that we discussed today is of great relevance. It also demonstrates that the Supreme Court need to step in and take action necessary at this point of time. And there's a requirement of a great amount of change that is expected from the people of this country, more particularly the kind of violations of law that has happened, and more particularly the kind of powers that are vested with the Supreme Court under Article 32, under the various provisions of the Constitution, which makes it such a strong institution. I think it's time that the Supreme Court comes up and stands, and the power which is vested, and it has to vindicate itself by taking proper, appropriate action, protecting civil liberties, protecting human rights. It's not the question of an individual, it's the question of the people of this particular country who are being denied that migrant labor, that farmer, that under trial prisoner, be it a tribal of Jharkhand, be it a person who is incarcerated in the name of the kind of abuse of powers by the state. as the case of Stan Swami or any of them, when you look at it, the court need to come forward and say that yes, rule of law need to be upheld, and two, that human rights are protected, the fundamental rights are protected. That's what we all believe in. The part 3 of the Constitution is sacrosanct, so important for us, so essentially important for us. And the court, it's not that the court does not know the importance of the same. At this juncture, this talk is so relevant on the subject when someone who raises questions, someone who questions the institution of its inability to address such a situation, does it amount to contempt? Is he not criticizing this institution? Is he not bringing it to the notice of this institution that yes, it has a responsibility to put forward itself to see that the people's rights are protected? I think the discussion becomes more relevant, and it is required that all of us, all of you, all of us need to discuss the subject all the more and express our opinion that this kind of prosecution for contempt, of scandalizing the court. Nobody is scandalizing the court. Everybody is criticizing the court. You need to understand the construct, the anger, the frustration, the kind of situation that people are facing in that has made people to react in various methods. I think that kind of maturity, magnanimity that need to be there in the institution is, I think, which many of us are feeling is missing in the courts today. I think it's time that we discuss that. In fact, at length, Mihir has explained the same. We are so extremely thankful for Mihir for joining us and explaining this matter in such a beautiful manner. We believe in this institution. This institution need to be protected. This institution need to be strengthened. This is a democratic institution. It's essential that a democratic institution is strengthened rather than being dismantled. In fact, it's not that we deny that particular aspect. We believe that this institution has to come forward. Our demanding strength for this institution is by asking questions that you are not doing enough. It's by asking questions. You need to ask the state certain questions because that's the institution which is meant for as a check against arbitrary executive power. That's the necessity of this particular institution. That's the safety valve of a democracy which is created in this particular, in this nation through the Constitution. I think that is something which need to be adhered to, that need to be understood, and each one of us need to discuss and raise this question. I thank Mihir, immense thanks to Mihir for being part of this talk show today and having accepted our invitation and delivering such a wonderful talk. Immense thanks to you, Mihir, and thanks to the entire team of ReachLawyer today, Prerna, Himali, Diksha, Nitin for hosting this show, and Shrikant, and pray all of them. It is amazing work that is being done today, and it's a joy to take on this show in continuum. Thank you very much. Have a great evening.